You're applying for asylum, but what about your family? Can your spouse and children be part of your case? In 2 minutes, here's exactly how it works. The short answer is yes, but the details matter. When you file Form I-589, your asylum application, you can include your spouse and unmarried children under 21 as derivatives. That means if your asylum is granted, they're granted asylum too, without filing separate applications. But here's the key requirement. Your spouse and children must be physically present in the United States at the time you file. If they're abroad, they can't be added directly to your I-589. For children, there are extra rules. Biological children, stepchildren, and adopted children all qualify, but stepchildren must have been under 18 when you married their parent. And adopted children must have been legally adopted before age 16 and lived with you for at least 2 years. Same-sex spouses can also be included if the marriage is legally valid where it occurred. And one important tip, list every spouse and every child on Form I-589, even if you don't want them included in your case. Full disclosure is required. So what about derivative asylum? If your case is approved, your listed family members receive what's called derivative asylum status. They can live and work in the US, apply for a social security number, and 1 year later, they can apply for green cards just like you. But what if your family is still abroad? Once you're granted asylum, you have 2 years to file Form I-730, the Refugee and Asylee Relative Petition. This lets you petition to bring your spouse and unmarried children under 21 to the US as derivative asylees. Miss that 2-year window without good cause, and the process gets much harder. Family reunification is one of the most important parts of asylum, but the rules are strict. Don't risk a mistake. Contact Jeelani Law Firm to keep your family safe and together.